You see them in airports and in train stations, but do they belong in schools? Sniffer dogs. This case involves a sniffer dog that detected marijuana in a teenager's backpack during a police sweep of an Ontario high school. The Supreme Court of Canada must now decide whether using a sniffer dog constitutes a search that infringes a student's charter rights. The school had a zero-tolerance drug policy. Several lawyers argued bringing sniffer dogs into a school was too heavy-handed and infringed students' privacy rights. But lawyers for the police and school board said students were warned about the possibility of drug searches. Civil rights lawyers say that the High Court might set a precedent here, and if searches are allowed in schools, hospitals, and shopping malls may not be too far behind. Joining us in studio, two criminal lawyers, James Drapopoulos and David Mercury, who's also a former Toronto police officer. James, the high school had a zero-tolerance drug policy. Shouldn't everybody have assumed they might be searched?
Well, we have a zero-tolerance drug policy at work throughout society, so should we all assume, no matter where we happen to be, that we might be searched?
I take it your position is this search should not have taken place.
Not without more than barren suspicion, which is all the police had.
Barren suspicion.
They knew it was a high school. They knew there was a possibility, as there is in almost every high school in the country, I would think, that there were drugs secreted somewhere therein. And that's what caused them to go in with the sniffer dog. That's it. Nothing more.
Nothing more. David, illegal search, was it unfair?
I think you have to look at it case specific. I've heard two different versions of how this happened. I've heard one version, the knapsacks were piled on the floor in the gymnasium, and the students were on lockdown, and the police took the dog and went and searched. The other version I've heard is that they were searching the lockers. So the dogs were coming up and sniffing the lockers, and then a dog indicated that there was something in one locker. The locker was opened. There was a knapsack, and then the knapsack was searched. If that's the case, I think it's more problematic for the police to come in and search the lockers in that way versus, or it's not as much of a problem, I should say, versus if they have this pile of knapsacks on the floor and then they come in and search. In the locker, I don't think that there's what's called a reasonable expectation of privacy. It's the school's locker. It's not your locker. But if I have my knapsack, like if I leave my wallet in your house, I wouldn't expect you to go and open my wallet and search it. I would have an expectation of privacy, even though it's not my house, it's yours, but that is clearly my wallet.
So you're saying that if the kids have their backpacks piled and abandoned, there were no students around the backpacks at the time, that they should have a charter right to feel like no one's going to look in their backpack?
If that's the case, because first off, from what I've heard, if that's the case, the knapsacks weren't abandoned. The kids are locked into their classrooms. They can't go and get their knapsacks. But I think that there is more of an expectation of privacy not to go into your knapsack versus if it's in your locker. You know, you can't expect that they can't go into your locker. You don't own that locker. You don't even rent that locker. It's given for use by the school.
Let's take a look at what the Crown is arguing at the Supreme Court of Canada. And we're going to hear very soon what the High Court thinks about this. The Crown said a dog sniff alone is not a search. It only supplies information that may lead to one. Now, you're laughing. You're laughing at the Crown's position, James. Why?
Well, if it's not a search, it's just the acquiring of information. It seems like a semantic maneuver on the Crown's part that I just don't buy. In substance, the information that it's disclosing is personal and private. It's telling the police something very important about what's in the bag, that there's drugs in the bag or there's not drugs in the bag. To say that's just information would, by analogy,
but isn't
you could
that
say,
reasonable grounds to suspect that a search might take place?
When the dog sniffs to give them that information, the search has already taken place, Paula. That's the issue.
Do you think privacy attaches to smell?
The problem I
statement?
have with that is you don't always need a dog. If the marijuana in this case is not wrapped up, you could be walking along and you can smell it. So is that a search?
Tell us.
I don't think it is.
Well, if it's available to the normal olfactory observations of the police officer, anyone who happens by, then it's in a very different sort of context, I think. There's something about drug sniffing dogs that's far more intrusive than you happen to be walking past a police officer and we're too silly to conceal the odor of your marijuana. I mean, let's not decontextualize this too much. A group of police officers went into a public school.
At the invitation of the principal.
Yes, but not at the invitation of the students, who are then required to remain locked down in their classrooms as a dog moved through the school in an effort to detect evidence to implicate one of them in criminal wrongdoing.
Should they not have been there?
Well, you see, I think that's getting away from the argument we were just having, okay, about whether normal olfactory sense, as you call it. I don't think that a dog coming along and using a dog that has a more sensitive nose, a more sensitive olfactory sense, I don't think that constitutes a search just because the search is more sensitive, or the instrument is more sensitive, if you will.
Well, I think we draw these sorts of distinctions in law all the time. There's a huge difference between someone overhearing your conversation on a pay telephone because you're speaking too loudly, and the state surreptitiously and electronically monitoring the conversation from within the telephone lines. And it's that sort of distinction that Mr. Mercury isn't drawing, I think, and that I think should be drawn. There's a different kind of risk involved with the one and the other. And we do accept that if we walk around stinking like marijuana because we're carrying lots of it and we're not concealing it well, we could be stopped and searched justifiably. And the idea that the police are going to subject us at their behest without any judicial scrutiny whatsoever, because that's what will happen here, to dog sniffing drugs whenever they like, well, I think they're of a different kind. The intrusion is.
I don't think it's the police at their behest in this situation. And I'm as much a civil libertarian as anybody. However, it's at the invitation of the school principal in this case. And as was said earlier, the students were given lots of warning. So I don't think there can be a reasonable expectation of privacy in that way.
I don't think the warning controls it, because tomorrow the state could announce that they're going to be opening all of our mail from here on in, so be warned. Would that extinguish our privacy interest in our mail because we'd be put on warning? And the fact that they're students, they're still citizens. They still have rights. The charter doesn't end simply because they're below the age of 18. And they didn't consent to this. And the question is, this isn't going to be restricted to schools. I want everyone to understand
That's what I was going to ask you.
The parallel case here, the case that was argued in tandem with this case of the young person out of the high school, was a case out of Alberta involving a man who was stopped at the bus terminal in Calgary, who was subject to questioning. And the rationale there was, well, we know, said the police, that drugs move through bus depots, that drug couriers use bus depots to transport drugs. And therefore, we have to take these extraordinary steps. And they subjected this fellow to a stop and a dog sniff. And of course, we know where it led, because the case ended up in the Supreme Court. They found drugs.
So they do say, David, that if the Supreme Court of Canada finds that this was an acceptable use of the sniffing dog
in the school,
right, that we could see random searches in all kinds of public institutions.
You know, I think that you can make that argument for anything. You know, the argument it could also be made when we talk about how the police have expanded powers in searching automobiles. You know, but it hasn't extended into the home. It hasn't extended into our person. So because this happened in the school doesn't automatically mean it's going to extend into these other areas.
I'm going to have to leave the discussion there. I can see you're still thinking. Our thanks.
I have something to say about
Next time.
Time's run out.
James Trabopoulos and David Mercury.